Good evening, hello and welcome. You're watching the Newshour Agenda on Times Now. My name is Pranesh Roy. Bilkis Bano's tormentors will continue to enjoy their freedom at least till November 29. While it is safe to assume that they will now be preparing for festivities, the woman who saw members of a family being brutally raped and murdered in front of her own eyes will continue to feel suffocated. Now, even while Bilkis's wait for justice gets longer, the reply filed by the Gujarat government has reignited the political debate around the moral validity of remission. The affidavit submitted by the state, in keeping with the Supreme Court orders, states that since the investigation in the case was carried out by the CBI, a central agency, it had obtained suitable orders, quote unquote, for the grant of remission of the convicts from the union government. Citing the affidavit as evidence, opposition parties are now gunning for the BJP, saying it establishes that the two BJP governments, one in Gujarat, one at the centre, colluded to ensure that the convicts were granted premature release.
It was the Modi government which gave its concurrence and approval for the release of the individuals convicted of gang rape. Secondly, this document, now in the public domain, reveals that this was stoutly objected to. CBI opposed it, and the special judge also did not agree and opposed it.
एक तरफ तो कहा जाता है कि महिलाओं को सम्मान देना चाहिए, दूसरी तरफ जो खुलेआम जिन्होंने हत्या किया, जिन्होंने बलात्कार किया, जिन्होंने छोटे मासूम बच्चों की हत्या की, उसको रिहा कर दिया जाता है। भारतीय जनता पार्टी की कहनी और कथनी में बहुत अंतर है।
इस तरह का जो भारतीय जनता पार्टी का महिलाओं के प्रति सोच है, यह स्पष्ट करता है कि भारतीय जनता पार्टी की कथनी और करनी में अंतर है।
The lawyer of convicts, however, insists that the whole argument of the opposition and critics is premised on morality, not legality of the case, and that is a factor that is insignificant in a court of law. However, Bilkis Bano's defense team is confident that their case has solid legal grounds to stand in court.
Supreme Court or any court of justice, there is no question of any morality. It is the question of legality which has to be seen by the every court. Otherwise, in every rape case, the court will see morality and convict without seeing the legal evidence. This is absurdity at its best. Morality has no place in Supreme Court judicial system. They have to go by the judicial records. They have to go by the policy as per the conviction date. The state government has also filed, as I told you earlier, that they have filed a very detailed chart which has indicated that the main basis for release, for premature release for these convicts, was that they have very satisfactory and good behavior in the jail. And that is what matters.
Legal infirmity in what? The requirement of law is that all stakeholders have to give their opinion, and that is a mandate. The CBI has said no, which is a prosecuting agency. The judge concerned, the court concerned, convicting court said no. Then, according to me, where is the question of remission to be granted to them? That's a mandatory requirement of law. That failed. Morality is one aspect, we can't even ignore that. But certainly that the order, according to me, is unsustainable.
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
Let's open this up. Desh Nigam, lawyer Naveen Choma, lawyer Rishi Malhotra, lawyer of the convicts Kamaru Choudhury, leader of the Congress party, advocate Tala Rashidi, spokesperson of the Rashtriya Ulema Council, completes the panel. Now, good evening, gentlemen. Rishi Malhotra, the lawyer of Bilkis Bano, says, and I'm quoting her, I'm sure you heard what she said, that the mandatory requirement of law is not fulfilled. This order is unsustainable. Mr. Malhotra.
According to her, what is not fulfilled? According to me, I'm responding to it. The mandatory, each and every requirement under the law has been fulfilled. And I say so with some responsibility, because earlier the plea by Subhashini Ali before the Supreme Court, there one of the speculative ground was that perhaps they have not taken approval of the central government. So on that premises, they have filed a writ petition in the Supreme Court. Now, when today the Gujarat government has filed an affidavit, a very detailed affidavit and a comprehensive affidavit, wherein they have also annexed the approval given by the central government under section 435, nobody is questioning the approval now. So I really fail to understand that on what basis a petition filed by a stranger, a third party which is not permitted in eyes of law, has been given effect to.
Kamaru Choudhury, would you like to take that on? He says, what's wrong? All the requirements were fulfilled. There's nothing wrong in it.
No, the point, yeah, Pranesh, first of all, a very good evening. You know, I am not going into arguments of the legality because I am not a lawyer per se, and I will not comment on the judicial process. My simple reasoning out here, what does the Prime Minister Narendra Modi ji claim? Beti Bachao. Now, what is the reality? The reality that the Bharatiya Janata Party is projecting out here is a Rapist Bachao. That is their slogan now. They expect that by giving the releasing the convicts of rapists of Bilkis Bano, they are going to garner some votes in the coming Gujarat election. That is their only motive. Otherwise, how will the Home Ministry clear such an important file within 2 weeks? You just can't imagine. We are just entering banana republic out here. Simple. Let me put it in a better way. We are living in a country where we worship Durga, where we worship Saraswati, where we worship Kali, where we worship woman as a goddess. And now in this same case, the rapist of a woman, Bilkis Bano, murderers of innocent people by these same convicts, they are being released on what pretext? You know, the pretext that the committee had given was they were Brahmins and Sanskari people. How ridiculous that can be. How can a rapist be a Sanskari? How can a murderer be a Sanskari? Why are they linking Brahmins?
Rishi Malhotra wants to respond to you. I am coming to you, Mr. Chomal. I am coming to you after that.
They have got good behavior.
Okay, let's hear from the lawyer of the convict,
I have got one
Rishi
more
Malhotra.
question. Now, does the Modi government...
No, you made your point, sir. Let's hear the other side. Yes, Rishi Malhotra.
Yeah, please don't mix political issue and legal issue. The legal issue is that they were not released because there was some sanskari and all that. They were released for the simple reason, one, they have undergone the desired period of sentence, that is more than 14 years of actual sentence. In fact, in this case, it was more than 15 years of actual sentence. Number two, what is more relevant is their behavior in the jail was completely satisfactory and good. They were not involved in any other offence when they were in custody. So where is the question of this sanskari thing and all that coming from? Please see the records which have been filed today
Rishi
before
Malhotra,
the court. Don't go beyond the records.
Mr. Malhotra, there are many people... Mr. Malhotra, now, while what you're saying is okay, there are many people who want one question answered. Why did the CBI and the special judge did not approve this? Why did they say no to this?
Yeah, I have answered to that also. Please don't forget the Supreme Court judgment of May 2022. It said very categorically, it directed very categorically that the state government of Gujarat has to consider the case for premature release as per the policy of 1992. Now what this judge, the trial judge, has done is, he has again gone back to the policy of the state of Maharashtra, which the Supreme Court has completely negated and said that no, that policy will not be applicable. It will be the Gujarat policy would be applicable. So the opinion rendered by the concerned trial court judge is only relatable to the Maharashtra policy. That's why time and again I'm saying in every channel, please see the records before
and why do you think the CBI said no?
Nobody has seen the records. Everybody
Mr. Malhotra, why do you think the CBI said no?
Supreme Court today said.
You see, there were 7 authorities, including consisting of 10 members of one advisory board. So if one of the authorities of the 7 authorities have given a negative opinion, does it whitewash the entire 6 other authorities which have said the positive opinion for premature release? You can't compare apple with oranges. The advisory board consists of...
Okay. Now what's your legal argument? Now you've heard Rishi Malhotra, Talha Rashidi. Are you convinced?
The Supreme Court today said that the counter affidavit filed by the Gujarat government is very bulky and voluminous. At the same time, it said that where is the factual statement? The Supreme Court asked the government where is the application of the mind. Now this statement itself says gives out impression what the Supreme Court is considering about the counter affidavit filed by the Gujarat government. The Supreme Court clearly said where is the application of the mind. The Supreme Court said where is the factual statement? You have filed in a lot of judgments, you have referred to a lot of judgments, you have made the reply a very bulky one, a very voluminous one, but where is the application of mind? What do you consider on this remark of the Honorable Supreme Court? As a person who understands the law, this particular remark of Supreme Court is sufficient for him to understand the gravity of the situation. On the second hand, I just want to put forward another point. Where in the world, in a civilized country, the Central Home Ministry of a country gives approval for premature release of 11 convicts who have been convicted under the charges of mass gang rape, under the charges of murdering 7 people, including a daughter who was of the age of 3 years, who was banged and killed through a rock, by bashing through a rock. Where in a civilized world we find such an evidence? And also the police, the CBI, the crime branch, the special court had opposed the release of these convicts. Still the Central Home Ministry went ahead with the approval of releasing these convicts prematurely, and then we saw how they were garlanded, how they were welcomed with sweets, and how the BJP MLA said that they were sanskari. Now at the same time the Parliament Affairs Minister today has said that this is as per the law. He welcomes the decision. Seriously, I don't have words to say how to express my feelings.
Now, Naveen Chomal, I'll bring you in, but Desh Nigam, as a lawyer, okay, 1 minute, Tala Rashidi, okay, fair enough, let's get a response. Desh Nigam coming to you, Chomal Saab coming to you, Naveen Chomal coming to you, 1 minute, sir, 1 minute. 1 minute, Desh Nigam, as a lawyer, Tala Rashidi, calm down, sir, you made your point, jawab to sun लीजिए. अब ताला रशीदी आप प्रॉम्प्टर से पढ़ रहे हैं क्या? आप बोल दिया, अब आपने सुन तो लीजिए. ओके सर, ओके, यू मेड दैट पॉइंट, यू सेड इट थ्राइस. देश रत्न निगम, where do you stand, sir? How are you looking at this?
Pranesh, in fact, the various channels I have been, the debaters are, divided between two sets of people. One, what the law is, and one, what the law should be. So those who are saying that they should not be released are basing their opinion as to what the law should be. And the ones who are saying the law has to take its own course. And in this particular case, the minimum, once a punishment is given and a minimum punishment has been undergone, it is between the state and the convicts. The victim is not in the picture. Please understand, as per the law. The Supreme Court also in a matter I think it is a case of Lakshman Naskar, very clearly laid down certain conditions that minimum sentence has to be undergone, there has to be a good behavior. Then there are other conditions, let me read it out to you, whether there is a chance of the crime being repeated in future by the convicts, whether the convict has lost the potentiality to commit crime, whether any purpose is being served in keeping the convict in prison, and socio-economic conditions of the convict's family. Nowhere the word victim is used here. This entire set of conditions which the Supreme Court has laid down is a whisk between the state and the convict. And once they have gone the minimum punishment which is required under the law, the courts have punished them, given the severest punishment under the facts and circumstances and the evidence on record. Once that has happened, it has to follow the laid down procedure. Our emotions could be separate as to they should not be released and what the future course of law should be. But the fact remains, the Supreme Court is quite clear, 1992 policy is quite clear, and we may agree with the decision or we may not agree with the decision.
No, but Nigam, there are many people, there are many people, and this is now getting a political realm. Many people are calling out the hypocrisy. Kamruzaman Choudhury, coming to you, sir. Deshrata Nigam, many people are calling out the hypocrisy of the BJP by saying that, look, when other cases happened in the past, this is what the BJP had said, but I don't even get into that. what explains, and people are saying that if the CBI, your agency that you trust and tom-tom about, if the CBI says no, why are you going ahead and approving this?
See, one thing, let me point out, under the law in the CRPC, in this particular case, no approval of the central government was required. No concurrence was required, only consultation was required under 435(1). Under 435(2), concurrence and approval is only required in the matter where the executive power of the union government extends. And union government's executive power extends to union list, and law and order is a state subject. I think it was a very bad move on the part of state government to have taken approval, because that was not the requirement of the law. However, one has to go by the law, existing law. What is the law on the subject now? BJP and other people sitting on a panel may do call sanskari and politics, but the law is blind to politics.
Okay,
and
Kamaru Choudhury.
I personally, I may say that law should be changed and these people should not be released. But the courts have to go by the rules and regulations and the law.
Kamaru Choudhury wants to respond to what you just said.
We know how.
You know, this gentleman out here, he is so triggering for millions like me on television who are watching. If the law is such that the convicts and rapists or the rapists and the murderers in the Bilkis Bano case are set free, then I better demand such a idiotic law must go. We cannot have regard for such a type of foolish law in this country. If Mr. Malhotra or Mr. Nigam thinks that whatever has happened as per law, then I better be on contempt of the court in suggesting that such an idiotic law be scrapped immediately.
Okay.
What the hell?
For that, sir, we'll have another debate. Kamru Choudhury, that's another debate of changing the law. I think Desh Nigam said that. Should we get into what the law is, what it should be? I'll get into that. No, Naveen Chomal. I understand your point of view, sir. I understand the sentiment, that you want to put across. But Naveen Chomal, yes, Mr. Chomal, people have linked it to elections. They are questioning the timing.
No. What Mr. Nigam said, I am totally approving it. In fact, continuing further, all over India, lakhs and lakhs of people have taken this benefit of the remission and the particular provisions of section 432, 433, 433A of the Code of Criminal Procedure. Every state has got its laws that whenever a life convict completes 14 years of sentence, there is a particular categorization, and counting the remission, they are released. So lakhs of people have got the benefit. In fact, in the crime world, Muslims are in majority who have got the benefit. You take the example of Nirbhaya case. Mohammed Afroz, only just because he was few months lesser than 18 years of age, he walked out free. So there they don't mind all this thing. But when it comes to Bilkis Bano, they are trying to say that the law is idiotic. So let us not allow these people to misuse this.
Please hang him. No one is, don't play a Hindu-Muslim card here.
Law is very clear.
No one is advocating them because they are Hindus, or no one is advocating.
You are playing Hindu-Muslim card over here, Mr. Kamaru. You are playing Hindu-Muslim card.
Please go and hang
by the law.
Don't play a Hindu-Muslim card here.
If you want, then all the Muslims who have got the benefit, send them back to the prison. All the Muslims who have taken the benefit, go back to the
stood with the Nirbhaya.
Why are you releasing
the whole country
also?
should stand with
Bilkis
Bano. That is the
lakhs of Muslims have got this benefit. They have been released after 14 years of imprisonment.
You should be shameful of your words.
So the law is applicable for equally for all.
Shameful of your words.
So you are Mr. Choudhury. You should be shameful. We are going by the law, and you are doing Hindu-Muslim politics
with the spectacles of Hindu and Muslim.
Please no, let's not digress, please. We are discussing something very sensitive. Gentlemen, please.
Yes, exactly, Pranesh. So the law is very clear. The CRPC provides that after convict completes 14 years of imprisonment, it is up to the state government to see how much remission he has earned, and if it
no, sir. But if it is on the state government, I'll give you 2 examples. Now, 1 minute.
Many laws, but there is a civil
Mr. Chomal, now listen. No, 1 minute, Mr. Chomal, listen. Advocate Rashidi साहब सुन लीजिए. ये देखिए 2 एग्जाम्पल है. June 2022, Siddharamaiah decides to withdraw cases against PFI. The BJP says It is unfortunate that the CM has disregarded the recommendation of the police officers on withdrawal of over 175 cases registered against PFI and KFD activists. Because the police had said no. Mr. Chomal, you're nodding your head. Coming to you. Ek aur example hai. There's another one, sir. There's another one.
Yes,
in 2012,
I want to reply.
in SP poll manifesto, the promise was we'll review all cases against innocent Muslims youth jailed on terror charges. The BJP said does not benefit scores of innocents.
Yes. So.
Yes, Mr. Chomal.
But no cases were.
So let me reply to you, sir.
But no cases
sir, I want to reply.
No, this is purely Mr. Chomal. Before you answer that, this is this is only on the principle that you're talking about.
Yes. No, I'm talking about law. I'm talking about law. There is a codified law that whenever the person is completing 14 years of imprisonment, he has to be released. That is a law. But withdrawal of the cases only because they are Muslims and they want to oppose Muslims is not a codified law. It was a political decision which was criticized by the BJP. So there is a big difference between the two, sir.
Yes,
so what
yes,
Siddharamaiah did was appeasement policy
so
and
you have
codified law to him.
This remission,
but what BJP government did in Gujarat was a codified law. They followed a codified law of which everybody is given the advantage. Even the Muslims have taken the advantage.
You want to make here, Mr. Chomal?
No, let's not make this Hindu-Muslim. No, please, Advocate Rashidi.
Because
sir,
they
please.
are Sanskari Hindus, they have been given the remission.
No, but no.
Why are you?
There is no debate on the garlanding bit, sir. Please, Advocate Rashidi, please. There is no debate on that.
Why is he using Hindu-Muslim again and again in the
Let's
debate?
not get into that, please. Let's not trivialize this, please. No, 1 minute. Rishi Malhotra wants to come in. Kamru Zaman साहब आ रहा हूं आपके पास. ऋषि मल्होत्रा.
You see, that's why I said from the very beginning, please don't mix an issue of emotional or morality with the legality. All this have been discussed is pure morality thing and all that. The law has to take its own course. The law is well settled that the policy which is applicable at the time of conviction by the trial court, that has to be seen. Now, what could have been argued today was that the 2014 policy of state of Gujarat did provide that a rape convict should not be released on remission. But that was not the case when this policy of 92 was in vogue, because 92 policy does not talk about all such things. Now, it may be fortunate for somebody, it may be unfortunate for somebody, but at the time of conviction, 92 policy was there. It did not specify any prohibited category like rape cases or rape cum murder cases. So what the Gujarat government has done with the approval of central government is only followed the law and only followed the Supreme Court judgment of May 22. I really don't understand that why such morality lecture is going on, because there was no death sentence ordered by the High Court,
Choudhury,
nor by the Supreme
Court.
Was followed. There was no hue and cry at that stage. Not today, there is a hue and cry after 15 years.
No. Rishi Malhotra says law is followed both by the state government and the central government. Kamru Zaman Choudhury.
Okay. I have just plain simple 3 questions for these 2 gentlemen who are defending the release of Bilkis Bano's rapist. Number 1, why has the Modi government, despite objections, sought to grant preferential treatment? Question, preferential treatment. Has the Modi government decided to pardon all convicted rapists and child murderers who have served a certain period? Will such treatment be granted to all individuals who are accused of such heinous crimes? The entire nation today is asking these 3 questions, sir. It's not a question of morality, it's not a question of law, it's a question of a vendetta, of an agenda that the BJP government is playing out here with the Gujarat elections in mind. That's the only logic.
Okay, we'll know what happens in Supreme Court on November 29. Gentlemen, we've run out of time. Thank you for joining us on debate number 1.